Hi, I'm Javier Ruiz. I'm an associate here at Sussex University, so it means I don't have to teach, but I'm just working with people at the Center for Technology and also the Center for Inclusive Trade Policy. And my background is basically I come from an open access to information from civil society, working with NGOs and consumer groups for many years, trying to provide access to knowledge and access to information. And through some practical projects, started doing more and more policy, and then I ended up now with quite a bit, mainly policy rather than practical projects. So I'm just going to talk a bit about text and data mining, which is slightly formalistic. And how do we pass this? That's the slides. Oh. Yeah. So. Just to say that there are this text and data mining, the wording is a little bit old-fashioned, but now it has become a really popular and current theme right now, mainly around the disputes around the AI or generative AI, particularly. And also it has become really relevant because there is now an open discussion about potentially changing the current regime as it is around this particular aspect of copyright. And there is a lot of strong opinion, both in favor and against of the changes that are being proposed. I think that you're probably all at least very aware that there are campaigns from creative industries and newspapers to try to push back against the AI training. And also there's a lot of social concern about what's happening with OpenAI and the potential for developing new forms of artificial intelligence that can go from short-term ideas of discrimination to the end of the world as we know it. There's like a very broad range of concerns. So we're just going to look first at what is the exception and where it came from, and then some of the issues with it, and then some alternative perspectives. So starting with the exception. So UK copyright law has a clause that was introduced in 2015, as an exception that allows people to basically carry out computational analysis of anything recorded in the work. And the key question here, and this is kind of a term generally as text and data mining, but not in every law it will be called text and data mining, but it's just an easier way to discuss it. But the key conditions in the UK is that you need to have lawful access to a material, which means that you cannot just download it or be torrent or something like that. It has to be something that you actually have either bought or obtained with a license. It has to be for research purposes, and the research has to be non-commercial. And then ideally you should have you should acknowledge that you've used that information or that data, but only if it's feasible. So it's kind of best effort approach. And something important is that you cannot, for example, if you are a publisher and you get, and I give you access to an ebook, in principle, I should not be able to put in the contract for the ebook that you cannot do text and data mining. So there is no contractual override of the exception. So that is the kind of general sense in the UK. Lawful access, research, non-commercial, and basically those are the main things really. The acknowledgement is not the important thing. Particularly the key question here is the non-commercial access right now. So the evolution of TDM. So 10 years ago, when this thing came along, there was a lot of discussion around big data and how, there were all these new ways of looking at text. There was a very popular thing around Google Books and the Ngram viewer, where you could now understand how many times people were looking for something and how many mentions of a word, particular words were in books, and people started discovering this idea of actually doing a lot of analysis of text. Then there was a lot of interest in the research community of doing things like looking at every single study that looks at a particular virus and doing some kind of analysis of both the studies and some of the data associated. It was machine readable. We tried to generate new knowledge. So there was like a big explosion of this analysis. It was not generative AI, but at the time there were already some ideas that you could start doing something like that. But now fast forward 10 years ago, and it's all about generative AI. And there is text and data mining involving how you access the content, the extraction and copying, and then the mining. So it's all the kind of preparation for generative AI could potentially come under this exception. So again, how we got here, the reason why that exception is in the law, both here and actually in the EU and other jurisdictions, is because there was already a big movement to try to, as we said, to try to develop research mainly around the text and data. And at the time, publishers said, like Elsevier said, well, don't worry, we are going to create mechanisms for you to do that. So we'll create our own platforms where you can go log in and do all the analysis. But the problem is that a lot of the research requires access to more than one platform. People want to use their own tools, and there was a huge complication with accessing materials that were out there, or even books that were potentially out of copyright, not out of copyright, out of what's called orphan works that were not available commercially. So there was a lot of push for this exception, starting in the UK. Interestingly, people from the British Library, they did a lot of the heavy lifting in the UK and Europe. And there was this parallel track, but then the UK got there first and set its own exception, but then Europe caught up. So, but this is very important to see, because actually science and scientific research was really at the core of the initial discussion on text and data mining. So it wasn't so much about generative AI, but this was that's something that is missed a bit right now. So the solution of having a copyright exception instead of licensing is a fundamental question around how copyright works. So copyright is supposed to balance the interest of the creators, to promote their creativity and protect them, with the interests of society. So you promote more and more creativity. So by giving people a temporary monopoly over the certain things like reproduction or distribution of their books or films, what you're doing in theory is to promote creativity for the interest of everyone. It's not just to say, well, this is now, it's just a license for you to print money, but it's supposed to have a social value. And when when the interest of a copyright holder clashes with the wider interest of society, in general, you tend to find what's called exceptions, which is they say, well, for certain things, like for example, blind people may need to have access to a braille copy of a book. So there are some exceptions that allow you to convert a book into a braille. And then there are lots of exceptions for research, education, and text and data mining now. And this map is quite outdated, but just to give you an idea that this happens all around the world. Every copyright, international copyright and national copyrights have a system of exceptions. And rights holders tend to hate this. They see it as a kind of expropriation, like a sort of communism, intellectual property communism, where society is expropriating their private property. But the reality is that copyright was created like this. So in the UK, the development of the exception started in 2015, but for a while there was a discussion on how the situation was not totally satisfactory. There were limits already in 2023. The UK already withdrew their initial proposal to reform text and data mining, but recently there was the new AI plan, and now totally framed under AI. There was a proposal by Matt Clifford, who is the entrepreneur, like the UK version of like big tech, I guess, that is who has proposed as part of the AI action plan to expand text and data mining for any purpose. And the idea is that basically to remove the non-commercial clause and to enable commercial research, so companies can start doing text and data mining. So this has generated a lot of pushback from the creative industries, who are arguing that basically they want license agreements that ensure remuneration for and also they say that the onus should be on the generative AI firms to pay for quality content, and that their collaboration between creative industries and technology industries should be based on like a licensing agreements, which goes back to the original slide of why this happens, because actually licensing agreements did not work in the first place. So it's a bit of a difficult position right now to go back to the original discussion. And but then the position of companies is actually the opposite. But they say, oh, you know, this even the current PDM, even commercial in some cases is too hard because in Europe where when you have like a ways of signaling that you don't want to engage, particularly in Europe, there is a TDM exception that allows commercial use, but you are allowed to opt out. And what they are saying is we should, OpenAI is saying that you should not allow opt-outs because their opt-outs are really hard to implement. So they actually push in the opposite direction, saying the government is not going far enough with extending this to more or less the European model. Then there are challenges. I mean, this is a slide from a project called Spawning, which is like, hey, how do you opt out to be in the training system? So there is definitely the idea that it has to be machine readable. So whatever you do, you need to create some machine readable system. It cannot just be a privacy policy saying, I don't want this material to be out of training. But it is actually quite involved. So here you're a creator, you go to this website, you check out whether your materials are in this database, which actually checks the LiON image, these 4 images. Database, then you go put a browser extension, and then some people have done a Fermi back of the envelope calculation, that it could cost around 25 million, for example, dollars in time to opt out of 100 million images, which is not a little when you are one creator, but overall, basically it's money that creators are doing for free for the companies. So that is the pushback on as it works right now. Then there are quite a few technological solutions and projects, some ranging from attaching some kind of metadata to the images themselves, so that creating registers of metadata that will link an image with a permission registry and create like complex architectures, depending on how people look at depending on how they look at technical architecture. If you are working on the web, so what they're just trying to insert it in the kind of HTTP protocol, like the other people that are working more on providing more things like, for example, online advertising, which they connect servers to servers. They say, well, we're going to create a new server that is going to have a repository of licensing agreement or opt-outs, and then you're going to do all the connections via this server. And then there are some people that are just directly saying that they want to create like a poisoning system where, when you generate something, it will put like some sort of watermark that will not allow the generative AI to take place. I mean, this is just like a small selection. There are more projects like this. But the problem with all of this is that, if you have to choose one, what do you have to do one, or do you have to do all of them? No one really knows. So I think it's interesting that right now there is a point of innovation in these things. This is mainly for how to opt out. But the reality is that it's very hard to see how is this going to work for people if they have to go to 20 different systems. And then, of course, there is a huge question, which is that this opting out doesn't solve a lot of the concerns, which is that what the creative industries want is fair remuneration. So if you opt out, you're not being paid. And this is something that is a big question. So there are proposals from some copyright people to create some sort of AI levy. So the training will be paid by companies in some sort of big bulk, payments, and then those payments will be distributed. But then there are organizations that have done something a bit like that, like Reddit, they wanted to do an agreement where they were charging for API access to their content for people who were training on that data, and the creators themselves, they were really, like the people putting the content on Reddit, they were really pushing quite hard. So there is a huge discussion, okay, how do you get paid, who gets paid, how do you distribute it, how much do you get paid if you've written like 3 entries in Reddit in your life, so you get a penny or so you get nothing, so there are big questions. But for Google, the response to the consultation was that the right to remuneration and the right to opt out are completely separate, and that the idea of bundling them, say, well, you are going to create a system where you are going to either opt out or be paid, for them is not. They're very worried about the idea of making the web like a pay per train model where you have to actually pay. So I think that they think that anything that is accessible, if you want to opt out, they will respect the opt out. And Google and most tech companies, they use a variation of what is called the robots protocol, where it's like a very quick and automated thing. But they don't want to have to deal with payments. So they prefer not to have access to some data rather than having to deal with having to pay people But the other problem you have is like, well, what about that may be good for creators and Google and thing, but what about me? So I have to opt out of training in LinkedIn, in X, and every single platform that I use as an individual, because copyright is a bit like the chemical weapon of the digital policy. It affects everyone. So you throw copyright and it affects, it's literally like a gas. It just gets, whether you are big or small, whether you are a scientist, whether you are Rihanna, or whether you are a blogger, or whether you just put a tweet, copyright covers everything, as long as that is there. So there is a big point that many of these solutions may not scale for individuals. And also the fact that many individuals actually also engage in producing AI. So this is like a program called Pinocchio, where you can download in your computer lots of different AI things to try. And a lot of this stuff, you may actually access data. You may want to take, do your own mini dump of like some Reddit channel and do your own analysis, or process your PDFs, for example, for academics, that's like there because the holy grail, to have a organized PDF collection. So I think that there is a lot of work there that is not really solved by a lot of this discussion. Then there are questions. So that was how the TDM is supposed to work. The problems we have at the moment are mainly around opt-outs, but also the payments. Now there are questions which is, okay, we have this thing that is TDM, and now there are some totally alternative ways of looking at this. And the first one is whether actually TDM should apply here at all. And this is something that is quite tricky, but that red line there is a really fundamental point of copyright. That is that when people created copyright law, if the idea was not to protect fundamental facts. So if a fact is a fact, pure fact, is not protected by copyright. Copyright protects the originality. So if I write, Mount Everest is 8,000 whatever meters, that is a fact. If I write, oh, Everest is the highest mountain in the world and it's 8,000 meters and it's below and it's got this shape, then that becomes copyrighted. And only that thing that I'm writing and I think that this is a fundamental question because if you are doing text and data mining, there is an argument that actually what you are doing is only accessing the information in the text, that you are not actually accessing the text itself as an expression. I mean, this is obviously I put it here as it's not a total, this debate, just to make it be clear. But this argument is actually being made by people like Google in their responses to a consultation to say, actually, really, we shouldn't be applying this, generative AI models, they are not looking at content, they're not really storing, they're not copying, and actually it's what is called non-expressive use of the copyrighted material. That's it says at the top. So if you are copying but not communicating the expressive aspect, like what the minion or the creator is trying to do, if you're a computer, that's just looking at its character or its group of letters, it's a broken down token or whatever. The idea is that this is not under copyright really, and TDM should not even apply at all. On the other side is the position that actually generative AI should not be covered by TDM because it's an expansion of the original idea of TDM. So some people say, actually, yeah, text and data mining is okay. You're doing that research and all of this analysis, but what you're doing here is recreating content. If you are going to write a song in the style of Madonna, at that point, this is fundamentally different. You are generating, completely new information, and the similarity that you are applying there is, basically you are copying. You are not just extracting some sort of meaning. What you are doing is you are creating a song that is just like a song from Madonna. This is can get a bit tricky, and also, but there is a whole pushback on the idea that text and data mining should apply to generative AI, but totally from the other direction. And this is, to be honest, quite a minority view, much more minority than the other one. The first one is actually all the top copyright scholars, really big, and this is a minority view, but it's worth mentioning because it shows the complexities. And it actually applies when you look at what is the end of the text and data mining. So For example, there is a case with the Lion database where they may be making that database, so taking lots of images from the internet, tagging them, classifying them, and making them available. The initial creation of the database may be under text and data mining, but there is an argument from some people that actually, when you start making it available for any purpose, that should be out of the text and data mining. So even the exception, the limiting at what point you finish your text and data mining use and you start doing something else, that is also a point of contention. Then another alternative perspective is to say, well, we shouldn't use the text and data mining because basically every time that you are bounding yourself, so we got an exception from blind people, an exception for researchers, an exception for something else, so you have to go and start. And every time that you have a new problem or a new issue, you have to go write the law. It takes around 10 years minimum from problem identification to changing the law, if you're lucky. So what some people are saying is that there are countries around the world that actually have what is called an open norm and a more flexible system, which is you create a framework for uses of copyrighted materials that more or less, don't have a direct impact on the creator. There are some tests that you can apply, and then you should just create the open framework rather than try to create a specific thing, because then you go back to, okay, but when it says text and data mining, does it really mean this? Or does, you start getting down into the detail of whether you got the wording right or not. But if you create an open exception, that could be easier. And this is what happens in quite a few countries. And particularly, Japan has got a very, very flexible exception, which is now seems like the paradise of text and data mining, because what they've done is they have decoupled, they've gone a bit back, not totally to the non-expressive works, but a little bit back to that point, and they say that they created an exception for what is called non-enjoyment, which means that if I'm looking at the copyrighted work, I'm reading a book, and the idea of creativity is that as a human, I am enjoying it. I'm watching a film, I'm doing something, so I am actually enjoying this. I'm getting something that is quite fundamental out of creative works. If I'm a computer processing tokens, I'm not enjoying this. It's just like a total machine. And it goes a little bit back to the expressive, non-expressive work. But this is, but the idea here is that there is a very, very broad exception for commercial, non-commercial, and based on this idea of enjoyment, which again, is kind of controversial. And then, there are some people pushing for this in Europe. It's still, I think, a long way, but it's worth mentioning. Then finally, going back to what I said, where I came from, is the open access movement. So a lot of the access to materials. So if you look at training data, the first thing you find there is like Wikipedia. That's a ground zero because it's totally available. Everything is there, and actually they have a lot of Wikidata. It's structured. They make it easy, and it's there for precisely this sort of thing. And actually, Wikimedia as an organization has been also pushing quite hard. They were quite involved in the exceptions and the process in Brussels, And then also Creative Commons, they're also another organization that has provided a lot of the core material. And then now these organizations are now having to go back and say, okay, whoa, are we that internet meme where there's the guy like David Mitchell with the Nazi uniforms? Like, are we the baddies now? So they are actually wondering, are we the baddies? I mean, are we actually enabling, this really bad, corporate takeover of all human content, to create the star, like the next generation AI that's going to kill the world? So there are lots of discussions and processes to try to say, is there a way where you can actually try to bring some balance, to particularly the idea of maintaining the idea of public interest and public access and avoiding a new layer of expropriation. So it's all very good to say the internet is accessible to everyone, but if then one organization has got the computing capacity to capture all that knowledge and generate the next something, then the idea of openness at this bottom, is like having like an open sea where when the cities are enclosed. So I think that there is a lot of discussion on how to create principles, like for example, around the benefits derived being accessible as commons, and then the idea of public investment in training data sets, or even things like sometimes quite relevant in the past few years, the idea of what's called traditional knowledge, like indigenous groups, that have got knowledge around plants or geography, so those things are now trying to be respected. So there is a big debate on that as well around the So finally, just to say, I think the key points for me would be that, as we see, there is a much bigger debate around text and data mining than just whether Paul McCartney or Elon Musk, should get all the pie here. And there are lots of people, particularly around science and around ordinary users in the middle, that are quite right now pretty much missing from the discussion. And particularly the research community needs to really get their act together to really make their voice a bit louder in this debate, because there is a possibility that, as I said, copyright is the gas of the policy. If you bring licensing for Paul McCartney, Elsevier is going to be licensing your materials, and you are going to have to license from Elsevier for doing data mining tomorrow. And then, the idea is that, we definitely need to look at fair compensation and what are the ideas, not just, for example, like privacy. That is not just copyright. There's a lot of stuff around individuals, data control, privacy, autonomy. So this is not to say that, these things are complicated, but bringing back licensing may not be the best way, in this, my opinion. Yeah, thank you.
Great. That was already quite. Just share. So follow on from the headache in copyright, I'm going to introduce more nuance in the patent regime. As I have been working on the patentability criteria, and there's a lot of new disruption arising from AI in the last few decades. And the first one you may come across in social media already. In the past few years, there have been a research team trying to use AI, register the AI algorithm as the inventor, the leading inventor of a product. And we have to redefine, or the judge have to define what is an inventor. So in the UK Patent Act, actually say inventor is an actual deviser of the invention, and the joint inventor should be construed accordingly. So they have to reconsider whether this needs to apply to a nature person, or now we can consider a robot, for example, here can be a lead inventor or a joint inventor. And it has been, in this case, it has been considered in this product. So this AI algorithm come up with this new container, the shape of the container, full container. So you will wonder, what on earth is this kind of full container? How can you clean it? It's not functional for us in the kitchen, right? But it is designed for operation in the store warehouse. So it could be grabbed by robots. So you can see the device has been thinking, following the robots' world or robot rules. So the team of researchers, they think, no, we are not going to claim the credit of this geniality, because obviously it doesn't exist in our kitchen. It exists in the robots world. So the Taylor case, or we call the Doubles case, actually has been applied in a lot of jurisdictions. Most jurisdictions have already rejected this claim of a robot or AI can be the lead inventor, but there are some jurisdictions that actually acknowledge that robots or AI can be the joint inventor if there is a leading human being in the research team. Then the second stage I would mention is the patent exclusions. So as you may know, not everything is patentable, although there's a famous American saying that under the sun, everything is patentable. But in the EU or in the UK, we do have some very explicit exclusions. The first column will be those things that are not inventions at all. In essence, it is not invention. For example, it might be a poem, or a song, or a mathematical formula, or E equals MC squared. That kind of algorithm couldn't be patentable. And I highlighted here, C is a scheme or mental act, a method for performing mental act, or business methods, or computer programs couldn't be patented. So now here comes the problem. So the law, it says computer program not patentable. They usually consider computer program more akin to copyrightable material, like a piece of lyrics or a piece of recipes that give instruction to the computer to perform in certain functionality. But then it is actually quite different from the piece of lyrics or a piece of novel or recipe, because algorithm, they do deliver some technical functionalities, right? So if you combine the algorithm with a smart device, then it could really change the performance or functionality of the product, right? And the other exclusion is called morality exclusions. Obviously, it's really difficult to define what is moral or immoral inventions. Now we can possibly say an AI algorithm calculated the extent to which people can kill themselves if they go under certain scores. That will possibly be immoral. So we can argue that for policy reason, for morality consideration, we are not going to give away monopoly for that. And here, computer program, we have a lot of debate over the last few decades. And basically, the left-hand column is purely mathematical formula or business methods, which don't really tie the algorithm to a device or hardware. Then it is not an invention. So it is purely still an algorithm itself. But on the other hand, on the right-hand column, where I said here, if this piece of algorithm can be fixated on a piece of apparatus or a piece of hardware, then it becomes a computer implemented invention. Then we can say that this algorithm is already elevated as the status of invention. So when the computer program was embedded in a computer, and which deliver a better efficient operation in terms of energy saving or in terms of its operation, then it could be a kind of invention. Or a computer program set into an electric drill, which help the drill to calculate the optimal drill methods in a rock. Then it could be a kind of a computer invented invention. And we can see a lot of smart devices as well. They already have algorithm inside. For example, cars have automatic brakes, or washing machine. You can calculate what time is best for energy saving or eco running of the washing machine. So this will be considered as patentable if we have already got the smart hardware or apparatus fixated with AI algorithm. So basically, in the UK, we have to follow the technical effect and following the Aerotel or microsome cases. So I'm not going to go through the detail because it's for my students, law students, to study this in detail. But basically, as long as if you want to apply for patent for your algorithm, as long as you can prove that has been fixated or run or operated in a piece of hardware and running to prove its technical effect or technical consequences, then it is possible to patent it. But there are a few. Finally, there are a few elements we will have to unpack in terms of patentability, when it is not excluded from maybe computer program exclusion, or maybe not excluded from morality or public policy exclusion. Then we have to fulfill 3 criteria here. So the first one is novelty. It needs to be new, right? You don't really want to give away monopoly to something that has been in the trade, on the market for a while, right? It's not, if it is not bringing something new to the table, then we are not going to reward it with 20 years monopoly. Then the second step is the inventive step. So after proving this device or this product is new, we also need to be, this kind of novelty needs to be not that obvious. So in America, we call this a non-obviousness. So it's this kind of inventive step is involving some twist. It's not that really straightforward or not really obvious to a layperson or anybody skill in the art. Because a person's skill in the art is theta. And then finally, it needs to be in industrial applicable. So we also call it utility. It needs to be applied in the trade, in the industry. But finally, this third criteria literally is not too much a problem. We are primarily scratching our head with the first and the second, because with the introduction of AI, if AI is coming to the public or public prior art, then how can we define what is prior art? Because AI definitely have more knowledge than the average person's skill in the art. For example, here, Iva, I assume your prior art will be smaller than AI, who encompass all sorts of prior art in the trade.
And so I've got a handful of patents which I did industry, so it was slightly technical patents for algorithms. One of the things which the patent lawyers that we work with said about the person skilled in the art is that you'd say that someone who can theoretically have access to any published information, and they could mix things together but couldn't create anything new. That was the way they explained it to me. So I guess in an AI sense, they kind of have access to all the information, but can't recombine it in, like, have a step of putting things together that have not been put together before. Is that?
So in the person skill in art, you can say, for example, in the plumbing industry, it will be an average plumber. So he wouldn't have the capacity to come up with a new product or come up with new solutions. So he's not a researcher, although he's a fictional average person, having reasonable level of skill, but he wouldn't come up with any new knowledge. Yeah, but then when we redefine or consider who is the person here, following from the W's case, where the court has been asked to define whether inventor includes AI robot, then they actually say in some circumstances it could. We could acknowledge AI algorithm robots as joint inventors, but then can we also include AI robots as one of the person's skill in the art? If that day comes, then we have to redefine what is prior art. And the prior will become enormous, then obviously average person or average plumber would be beaten immediately. And the other question is enabling disclosures. For you to acquire the patent, you have to make a disclosure to the public that all your know-how has been done, and you need to disclose this to the person's skill in art sufficiently and clearly so that the person's skill in art can rework this invention. But then the level of disclosure will be higher. You need to teach them in a lot of more detail. For example, not only the step-by-step know-how, but also maybe the training data behind that and the apparatus of metrics that have been involved in the training process. So that is the nuance that we have to consider. Now, AI is put in the game, then the disclosure requirement will be higher. And the sufficiency of disclosure here also will be different from inventions that without AI involved in the invention. Especially when we just want to also correspond to the disclosure or transparency requirement in AI governance. As you may also know, the AI Act already set out the principles of explainability or transparency in AI governance so that we can verify the functional aspect or the safety metrics of AI models. We can see that there are a lot of requirements embedded in GDPR, General Data Protection Regulation, and also with the new AI Act. There will be requirement for disclosure. And this kind of requirement, whether it has direct connotation or implication on the patent disclosure in terms of enablement and sufficiency, we will need to reconsider whether this kind of correspondence will help the better data in AI governance. So finally, I just briefly mentioned that will be a problem of the change of criteria of trade secrecy and patent disclosure. So previously, I've already said when you want to apply for a patent, your previous know-how lie in your own pocket will now disclose to the public. But then not every know-how or every detail has the status of trade secrets. Some are factual secrets. So now you also have to define what can you really put behind as a factual secret and what can really be protected as trade secrets. And there will be different criteria for disclosure with regard to patent disclosure and different method when you want to safeguard it as trade secret. So basically, you will possibly also, when applying for patent, now you need to, in some cases, it is required now you have to disclose your training data. But this depends on jurisdiction. So different jurisdiction may have come up with the different solutions. And here, this is one of the argument here, in terms of reproducibility and repeatability of AI algorithm, you have to disclose the training data. So there are a lot of detail you have to consider. I'm not going to go through this, but the slides will be available, is recorded. And so you may need to require to disclose the updatation methods and how the algorithm changes. Or explain how the adaptivity has been involved in this AI system, and the full set of parameters that have governed the adaptation. But the human expertise that used to select the data or train the algorithm is not required for disclosure. Finally, looking forward, we are looking at a changing landscape of intellectual property. We talk about different ideas of exceptions and different ideas of criteria for disclosure. And now we will also really look at international harmonization. As Javier's one of his slides, look at the different jurisdictions have different approaches. But then it is really hard to find an AI system only existed in the UK market, right? It normally has all sorts of jurisdictions or major jurisdictions across the world. So we are really looking for international solutions for that. And we will also need to consider how the patenting system respond to the principles of AI governance, especially when it comes across safety and transparency requirement. We will need to consider as well the problem of AI as a tool or as a potential to exacerbate bias discrimination, and how can the patent system address that? And how can we consider all factors and all stakeholders who hasn't been included on the table, and how can we consider their benefit and their interest so that we can really have AI for human flourishing. So yes, I start here and welcome your questions. We have like 10 minutes.
I was wondering if you had an example of an AI model which had been patented for something, like an actual model, because there's quite a few instances, like Google patented a lot of the training procedures and algorithms. So it's like the machine learning people are familiar with dropout, which is particular, or using or CNNs for classification. So Google patented all those things many years ago. And that's training algorithms. I don't think it's forced that, but actual models for something. I don't remember seeing any.
Yes, there has already been quite a lot, really. A previous version of my slides actually include one case study, but due to the time constraint, I deleted. It basically is saying like the algorithm maybe try to calculate your heartbeat, and it will give you a optimization of what kind of treatment is required. So that also has been already fixated in a piece of apparatus that is patentable.
And that had like training data which had to be disclosed as like, I was just wondering how much.
Yeah, so this case I talk about is previously I checked on WIPO. The training data disclosure was a requirement in the European Patent Office, but in the same case in America, it wasn't required. So I need to update whether there's a change, but I checked previous time last year, it wasn't harmonized at all. So in terms of people may come to US for more generous for patentability, but the EPO is almost always a bit different. Any other questions? Yeah.
I don't know if it's a question or a comment, or maybe just trying to understand a bit more. Because I guess if I compare the first part of the talk, which was more about the creativity in the creative industry to some extent with copyright and how to protect and also how to enable creativity by not protecting too much, I guess. And then patenting is more the industrial aspect of things, but in both sides, I see like the praxis. How do you make money out of your kind of AI use in the creative industry or in an industrial context? So how do these two things come together? Because at some point, there would have to be a policy that covers the two at the same time.
I mean, the law is the copyright, patents, and designs, but I think from the point of view of copyright, I mean, patents, they have the trade-off is that you are disclosing something in exchange for protection for 25 years or whatever. And so that is the kind of public interest trade-off to say, look, rather than make a black box, I'm going to disclose it. So in the context of AI, something that is interesting about the patentability is that patents are designed to stimulate the creation of more AI, more invention. So the idea when you patent something is that I'm going to look at that algorithm. I mean, it's not how it works, the reality of patents that you use as protective they call patent modes, and to stop other people from doing things. But the theory is that I should be able to look at your patent, reproduce it as the person of whatever, and then actually think, oh, this can be made better. I can actually work on, and then using that as prior art, then make a much better version. And that is the theory of innovation with patents, that you're using. With copyright, it's a little bit different because the idea is that this kind of creativity and thing is more like a diffuse sense. So you are only protecting that initiative, that particular text or image. But it's almost like a protection after the act. So I have created something and then I get protection. And then the protection ideally is going to encourage me to then create the next thing rather than go and work in a factory or whatever. That's the theory of copyright, but it doesn't have this kind of built-up effect. I think that is quite important to see with, I think another aspect to see in patents, that is how do you actually enable then build up? And in copyright, the question is not so much how do I build a better version of how can I use Picasso to make better cubism or to develop something else, which is supposed to happen almost naturally. But it's how do you make sure that if I am blind, I can still read a book. So it's a slightly different angle, the idea of the idea of like the build up and the, how do you do like what's called derivative works, and there is a slightly different, but I think in both cases, there is definitely a very strong public interest component there. I mean, the state is basically sending people potentially to prison, for violating your intellectual property. So it has to be quite a strong public interest. I don't know if that makes sense, it's like trying to understand. So complicated, all of this. That's the other reason.
Patents between like industrial secret and patents. How does that, I mean, is it formalized? Are you obliged to disclose? How does that work?
Yeah, if you want, obviously, before going to,
Patent, but you prefer to keep the industrial secret.
you can still keep it secret. Now, because obviously there's a higher level of disclosure, a lot of companies, they actually go back to trade secrecy protection because they say we could still have this in our pocket for as long as we could.
The patent protects you from the industrial theft, I guess, because if someone steals it and you protect it by a patent.
So if technology that's easily being reverse engineered, then anyhow you should possibly still patent it so that you can actually get a piece of paper that you can enforce it.
No one else can do the property, try to keep it secret.
Yeah, like a Coca-Cola or Kentucky Fried Chicken recipe. If it is really hard to reverse engineer, then you may as well just keep it in your pocket.
Yeah. And there are protections for trade secrets. I mean, there are.
Like it's copyright. The idea is you put it out in the public and you want people.
Well, not necessarily. I mean, they think it's a bit. So there is actually unpublished works. They have their own. So if you write something and you put it in a safe box for 50 years and then you publish it 50 years later, there are some really complicated rules on when the copyright starts acting. The copyright is, it can get ridiculous at parts, to be honest. I mean, it's almost like, because this legal fiction, that everything that you write, you create a doodle on a paper, that's copyrighted. I mean, literally, is this really broad? Then you can go back to say, okay, maybe not, maybe it's, but the idea is that it's really like a very, very broad protection of creativity. Anything that is expressed potentially can be copyrighted, unless it's like minimum. I mean, there are some minimum things, so you just draw a line, maybe not, but if you do something with a very, very low barrier, it's copyrighted. But I think from what you're saying in AI, I think that there is the question of EDM is around the inputs, and I think that the things that you are using, I mean, a lot of these AI, well, a lot of pretty much everything more or less requires some sort of input of information to be able to generate something else. And I think that the question here is that everything that you're going to use pretty much is going to be almost for certain, there's going to be some sort of IP involved in that input, even if just to discuss whether there is no IP. Even like a table, I mean, if you can get like, for example, sensor data may not be copyrightable. So if you set up a sensor and you start getting like temperature, micro temperature readings or vibrations from a seismographer, that will not be copyrighted. It could. So there are other things, but you would still have potentially questions of access. So it's not that every single data is going to be under copyright, but if you are looking at text or images or things like that, you would be.
Sorry, the discussion. So maybe someone has a question, but how about personal data? Like the ownership of personal data.
Yeah.
Where does that sit in this realm?
So it's kind of.
You're talking about GDPR, right?
Yeah, the personal information.
They're not a regime, it's not a property right, but you do have the confidential.
But I'm thinking like before, what you had an example of skimming data from the discussion forum, right?
Yeah.
And people essentially expose who they are by stating opinions, right?
Yeah.
So at some point, how much do you own that opinion that is out there and it's about you and how there's a creative process behind it.
So it can be personal data. So that will be a parallel analysis. And there is, in parallel to this whole discussion around copyright and IP of the data, there is the question of the use of personal data for training. And there is a big discussion on to what, I mean, in Brazil, I think, for example, the Meta has been ordered not to use that data for AI training. In the EU, it's kind of a bit up in the air. The UK, I think at the moment, they're kind of a bit more permissive, but there is that starts getting into like really detailed questions like, do I have the right to do AI training like the same way that I would do other processing of your data, for example, to serve you better adverts, or it can get quite detailed, but I think that there is, yeah, it is definitely an issue. I don't know if there is. For patents, I don't think there is so much, no, the personal data. So, I mean, it's not copyright and personal data is like
Fabri's class on personal data protection, so it's separate but in parallel. So today we are only dealing with property right, intellectual property, the ideas that you can protect it as a tool for commercialization. So it's different from your personal data from the hospital.
But the important thing, I think, is that personal data is not a property. And actually, there is, in the UK, there is no concept of property on data as such. It's
like data such like your hospital records. I meant more like your identity also as a creator in the public domain, and how much is yours and how much is.
So if I use your Reddit post to create a profile of you, for example, then you start crossing the realm very clearly from copyright to data protection. But if I'm only using them, they may be scared. But I think that the one important thing there is that with copyright, I may be able to license my content. So if when the company says, oh, we can get a license, and you can then maybe get an agent or someone to license. With personal data, the idea of licensing personal data, it's a lot more complicated. I mean, there's no simple way, and lots of people have tried, and they're setting up things like trusts and lots of complicated things, but it's actually not that easy.
Okay, I think we have already exhausted the hour. Thank you for your attention, and we look forward to further conversation in the future.